Hi students, in the previous lesson we have covered genesis of insolvency and bankruptcy laws. In this lesson we will cover objectives and scheme of the Insolvency and Bankruptcy Code 2016. We will also deal with the important parts of this code in the subsequent lessons. As discussed in the earlier lesson, the Insolvency and Bankruptcy Code is one of the most progressive, dynamic, radical modern day statute in the contemporary times. This code is well received by the creditors, investors and debtors alike. The distinctive feature of this code being streamlining of the procedures, simplification of the insolvency process and fast tracking of recovery, which provided an affirmative effect on India's lending climate. The intention of this code is to do away with the antiquated existing laws. The code deals with nearly all the aspects and elements of insolvency and bankruptcy, which provided a significant leap in the operation of the financial market. I would like to emphasize that in the present economic scenario of the country, a well operating bankruptcy regime is a sine qua non to ensure financial discipline in the successful market economies. Let us first discuss about the objectives of this code. First objective is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals. The other important feature of this act is to conclude the process in a time bound manner, which is very important. None other legislations have got this feature. The point is, all the activities under the act have to be completed with a time bound manner, say for instance, and short term time. Say for instance, once IRP, Insolvency Resolution Professional, is appointed, you have to complete the process, issue advertisement within 3 days. The entire process he has to conclude within 330 days, which is very vital, and none other legislations have got this type of the timeline. That is why this is called a successful legislation. The other important aspect for maximization of value of assets of the persons, that is persons, here we mean the corporate persons, partnership firms and individuals. How it maximizes the value of the assets of such persons? Students, what happens when the person borrowed the money and not paid the money to the banks, and or if the value of the assets are held up and declared as NPA, the assets are no value to him. So, once he realizes, then he can maximize the value of those assets, which is implied, and also to promote the entrepreneurship availability of the credit. Once the banks have lent the money to the borrowers and the amount is held up with the borrowers, and if the bank do not receive the money, the banks will go to insolvency. That was the scenario. As I said, lakhs of crores of the money of the banks were lent to the borrowers and they have not paid. Therefore, the banks were not having the money, and now after the initiation of this particular legislation, fast recovery, banks have started fast recovery of the loans. So, they got more money and they were able to lend the money. So, availability of credit was more and they were able to promote the new entrepreneurship. And also the other objective is to balance the interest of all stakeholders, including alteration in the order of priority of payment of government dues. If you see the previous legislations, the government dues had ranked the priority. First, government used to get the money, government dues to be paid, thereafter to the secured creditors, unsecured creditors, etc. The waterfall mechanism was something different. Now, under this new legislation, first the secured creditors will receive, thereafter the workmen, employees dues of 24 months are to be paid, then only the government gets the monies. So, that is how the government dues are not prioritized first. And also the other objective is to establish an Insolvency and Bankruptcy Board of India. It is a very good known as a very good regulator controlling all stakeholders like insolvency professionals and the IPAs, etc., etc. And the other objective is, of course, and for matters connected therewith or incidental thereto. These are the prime objectives. Whenever an act is or code is to be interpreted, even the Supreme Court judges or Supreme Court senior advocates look to the objectives of the act. Now, let us understand how the code is framed to achieve these objectives. If you see the scheme of the act, this code has got 5 parts. Any act, basically divided into chapterized into parts, sections and schedules. Schedules are the last part of the act which are used to provide an additional interpretation or to elucidate certain meanings of the provisions of the code or act. Now, as I said, we have got 5 parts and 255 sections. Now, how these parts are divided, let us understand one by one. Part 1 contains section 1 to section 3, which is preliminary. Part 1 is similar to all the legislations. Normally, you ought to understand what does section 1 says. In any legislation, either code or act, section 1, now this is a generalized section to all the codes and all the acts applicable. That is why I just wanted to spend some time on this. Now, section 1, subsection 1 says name of the code. Name of this code is the Insolvency and Bankruptcy Code 2016. Likewise, section 1, subsection 1 always in all the acts, like say Minimum Wages Act, it says the name of the act is Minimum Wages Act and Factories Act, the name of the act is the Factories Act. So, section 1, subsection 1 is common in all the legislations. Now, section 1, subsection 2, it extends to whole of India. Earlier, certain acts were not applicable to the Jammu and Kashmir. Now, after making the Jammu and Kashmir as a state, then most of the legislations are made applicable to the whole of India, including Jammu and Kashmir. Now, this act applicable to whole of India, including Jammu and Kashmir. However, part 3 of the code shall not extend to Jammu and Kashmir. Why the part 3 of this code is not extended to Jammu and Kashmir, I will explain when it comes. So, and then section 1, subsection 3 always in all the acts, I repeat, it says that when this code or act comes into force. So, similarly, then in some of the cases, it says this act comes into force immediately or from the date of publication in the official gazette, or it may say that it will come in part wise, etc. So, section 1, subsection 3 always says about the date of enforcement of the particular legislation, act, code, etc., etc. Now, section 2 is specially designed in this code, because this is, as I said, is a most important economic legislation, where the lot of questions will arise. Therefore, section 2 is specially designed, say, stating and to emphasize about the applicability of this act, because it is the economic legislation having force on the individuals, companies, partnership firms, etc. Therefore, everybody will question about this applicability. That is why, to give a clarity, section 2 has very clearly mentioned that this code applies to any company incorporated under Companies Act 2013, very clear. And it also says it applies to companies governed by special acts. Certain companies are formed under the special acts like LIC or financial lending NBFCs, etc., etc. So, when the companies are formed under special acts, to them also this code applies. Similarly, this code is also applicable to limited liability partnerships, famously known as LLPs. So, this and then such other body incorporated under any other law for the time being in force, as the central government may by notification specify. The central government has so far notified regarding the applicability of this act to many of the organizations. Now, an important aspect 2022 amendment of this legislation is the code applies to personal guarantors to corporate debtors. Students, what happened when this legislation, this as you know 2016 legislation, when most of other legislation or our pre-independent legislations. This is very, as I said, it is very important legislation. So, when the, mainly to recover the loans from the companies. When a company is formed by certain promoters, what they do? They apply for the loan from the banks or financial institutions. They borrow, the financial institutions and banks initially they may be hesitant, they may not be able to give the money, and therefore, what the promoters do is they give the personal guarantee, saying that if the company do not pay, I will pay. So, this is how the personal guarantee is given by the promoters to the banks on behalf of the borrower, that is company. Now, see what happened after initiation or enforcement of this legislation, it is initiated against the companies, individuals or the partnership firms. Now, the companies once initiated, company was not having money because by that time all losses were there, then from whom it should be recovered? The question arose that the banks can approach the personal guarantors because they have given the guarantee. Based on that guarantee, the amount was lent to the company. So, then there are a lot of petitions went up to Supreme Court, including Reliance matter and IL&FS matter, Jet matters, where promoters were there. They were rich, but the companies were not able to pay. Therefore, what happened? The amendment was, there was no clarity regarding the applicability of this code to personal guarantors. That is why this amendment is brought. Now, the code is applicable to the personal guarantors to the corporate debtor as well, which is very good feature. Now, all the personal guarantors are afraid, the banks have started initiating proceedings against the personal guarantors. And this act is also applicable, as I said, partnership firms and proprietorship firms and also individuals. That is why section 2 is important, and because it gives the clarity about the applicability of this code. And this applicability is in relation to the insolvency, liquidation, voluntary liquidation, bankruptcy as the case may be. So, that is how section 1, section 2 have covered enough, and then section 3. Section 3 always covers the definitions. Definitions are very important for interpretation of any of the code or any of the act. And then let us come to part 2. Part 2 is like a body of this legislation. Part 2 covers insolvency resolution and liquidation for corporate persons. Normally, the amounts are borrowed by the companies and corporate persons, here I mean two, that is companies incorporated under Companies Act or companies promoted under a special act, and also the limited liability partnerships. These are the major entities which borrow money from the banks. So, applicability of the part 2 is very important, and it applies, as I said, to the companies and limited liability partnerships. The detailed provisions of this part 2 I will cover in lesson 3. So, then other important thing is chapter 3A of the part 2. This code came in 2016. The new provisions, chapter 3A, 54A to 54P, enforcement from 1st April 2021. Why these provisions have been incorporated, thought in 2021? During COVID period, mostly MSMEs, that is micro, small and medium enterprises, has suffered a lot, and they were not able to pay monies, they were not able to have production, marketing, etc. If the force is brought on the MSMEs to recover money, they will not sustain. Therefore, government has given a lot of thought to it, and they have brought in a special provision, that is chapter 3A under part 2 from section 54A to 54P, because this has got a special features, because the other process involved to normal companies, to normal limited liability partnership is little cumbersome. So, they have reduced certain the processes, compliances and brought in this particular provision, and this part I will cover in detail in lesson 4 please. Now, because part 2 other important things also there, the fast track corporate insolvency resolution process is there, voluntary liquidation process is there, and very important thing that is there in part 2, other important area I want to emphasize and cover is offences and penalties. Dear students, what happens is we have got age old legislations. I mean that most of the legislations are pre-independent legislations. At that time, the penalties provided under each of those legislation is minimal, not the prohibitive, rather they will not, the offenders used to easily escape because the penalties are limited or less. But in this 2016 code, they have incorporated, they have strengthened the penalties for the offences, because these are economic offences, they ought to be penalized. The penalty even go up to 1 crore in some cases and imprisonment in most of the cases, because it is an economic offence. So, therefore, what I mean to say is that this aspect has to be thoroughly covered. Therefore, I thought that I have to cover this particular provision in lesson 5. Students, come to part 3. Part 3 covers insolvency resolution and bankruptcy for individuals and partnership firms, whether they are registered or unregistered. Friends, I would like to emphasize one thing here. The point is the age old legislations used to govern the individual insolvency under Presidency Insolvency Act 1909 and Provincial Insolvency Act 1920. Age old legislations having no effect and lot of procedures, cumbersome processes, etc., that were ineffective. Replacing that, the part 3 is incorporated in this IBC. So, however, the unfortunate or fortunate, I do not know, for the time being, the part 3 of this code is not given effect to even today. I will cover why government is hesitant to bring in to force this part 3. I will cover in lesson 6 when I cover this in detail. Friends, the other important is part 4. Part 4 is also important part of this legislation, being how to implement. Implementation is also very important for any legislation to be successful, which is very important. Most of the legislations in India fail because they are not properly executed, not properly implemented. Now, in this code, because it has come recently, they have brought in lot of reformations. Important thing is they have created a profession called insolvency professional. I am proud to say I am an insolvency professional. Now, this insolvency professional is the one, any professional, a chartered accountant, a company secretary or cost and management account, a lawyer or any manager having experience of 15 years or more can become an insolvency professional by writing certain examinations conducted by IBBI. And these individuals, professionals, conduct the legislation, processes. Why I am saying this is important provision is, earlier we have seen liquidators. Liquidators were associated with the registrar of companies and to the high courts. Lot of lengthy processes. There were, they were not able to liquidate, resolve the things. Running the liquidation process into years. Even the World Bank report said 4.5 years, 5 years liquidation process. Now, under this legislation, through the private agencies, that is professionals, a discipline is brought in and the process had to be completed maximum within 330 days. So, all the insolvency professionals are now obligated to expedite the processes. I said in the preamble when I said the main object of the act is to complete the process in time bound manner. Now, that is what insolvency professional 330 days is the maximum period within which all the process are to be completed. Similarly, certain insolvency professional agencies are created to assist IBBA. Other important feature of this Act code is information utility. Students, nowadays the average time taken to resolve the dispute in a civil court is more than 5 to 10 years. Now, if that is the case, how the justice can be expedited? Impossible. Now, why the cases are delayed before civil court? Because they do not have the information. Now, I mean, suppose if somebody said I have given money to X, X will say no, I have not borrowed. This is what the dispute. So, whether that evidence can be stored somewhere was the thought process given by the the lawmakers. They have created information utility, which is very important source of information. So, when the bank lends money to a borrower, it furnishes the information to information utility, and information utility takes a confirmation from the borrower, friend, somebody said that you have taken loan, whether it is fact or not. The other person ought to confirm, then only the bank will release the money. So, other person will confirm. So, authenticated information is stored somewhere. Suppose if the case is filed that the borrower has taken the loan and he cannot deny now, because already information is there in the information utility. So, therefore, it is easy to the NCLT, National Company Law Tribunal, or any adjudicatory authority to expedite the matter, because the evidence is very clear now. So, this part of the thing, that is the provisions relating to insolvency professionals, insolvency professional agencies and information utilities, I will cover in lesson 7, which is also very important. Part 5 is very simple, miscellaneous provisions, and which are not much important. We may not be able to cover that. So, which is also not much important. Now, we have now covered part 1 to part 5. Now, come to schedules. Schedules, there are 12 schedules. For students, all these 12 schedules are consequential amendments. See, now what we said is the insolvency and liquidation process to the partnership firms. Consequent to that, the existing partnership act had to be amended, certain provisions are to be amended. Therefore, what are the provisions that are amended to the partnership act are laid down in first schedule. Similarly, second schedule deals with the amendment to Central Excise Act. Likewise, third schedule deals with the amendment to Income Tax Act, and fourth schedule deals with the amendment to the Customs Act. Similarly, fifth schedule deals with the Certain Institutions Act, and Recovery of Debts and Bankruptcy Act 1993 is renamed, and that is what is the provision which is there in fifth schedule. And consequential amendments were also there to the Finance Act. These details are provided in sixth schedule. Seventh schedule deals with the amendment to the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Act. And eighth schedule covers with the amendment to the Sikh Industrial Companies Special Provisions Act. Not amendment, the SICA, as I said, SICA is repealed now. SICA earlier legislation was SICA, Sikh Industrial Companies Special Provisions Act, which was dealing with the insolvency process, which utterly failed in spite of providing so much of infrastructure, creating BFR, Board for Industrial Financial Reconstruction, having 24 floors building in Delhi, which totally failed. So, therefore, now that act is repealed. Now, ninth schedule deals with the Payment and Settlement System Act 2007, and 10th schedule deals with the amendment to LLP Act. 11th schedule deals with the amendment to the Companies 2013 Act, and now very important thing is 12th schedule, which I will elaborate when I cover in the part 2 in detail, because this amendment is brought in 2012 mainly to cover the persons. What happened? The promoters were playing the games. What they do is, some cases, I am not attributing it to everybody, some cases they make the company sick, and then they, after availing the facilities, they want to take over. To avoid that, who are the persons who can bid to take over the company which has become sick? So, those persons who are not eligible is mentioned in schedule 12. So, that last schedule is very important, and I will definitely elaborate on this schedule 12. Thank you, students. In the next lesson, we will discuss about the important features of IBC and key issues and challenges in its implementation.